So there's no need to come in hot with, you told her she could appear by Zoom. I already know that it's on the docket. Just
Judge, I feel like you don't want to hear the response, but it's important because
the matter that she's going to another county for, is that a jury trial?
It's not a jury trial to my
This
understanding.
is, she should have came here first.
I understand that, Your Honor. If I could just be heard at.
No, she needs to be here.
I have to ask you, is this a tactic on the court's part to attempt to wear out the defendant so they can't access their right to trial?
Courtrooms are meant for justice, but sometimes attorneys take things too far. From outrageous outbursts to blatant disrespect, Judge Boyd has seen it all, and he doesn't hold back. Here are the top 5 craziest attorneys who got put in their place.
The attorneys and the defendants, are you doing this for the YouTube? Because we don't have a record, right? Except for the.
Let's dive in.
All right, I'm going to ask you the same question that I asked everybody else. Has an acknowledgement of discovery been done? Because I don't have it in the court's file.
I have signed a few of them at this point.
All right, so has there been any new discovery?
Not to my knowledge.
All right, so you can make sure that the acknowledgement of discovery, the state actually has it and the court has it, because it's not in the court's file. And Odyssey is doing things on its own. So I'm gonna have y'all come back tomorrow. You're not number 1 on the docket.
Okay.
There are a couple of cases that are ahead of you, so those cases may end up going for 4 years. We'll just see where we are, okay?
That's correct.
Respectfully, Your Honor, Mr. Rios always appears, always waits all day. This is impacting his employment. We would ask that if we're not likely to be called tomorrow, that we be released. Additionally, I have experts for this trial that we have attempted to bring in, but we never know, and because the case is older now, when we should bring those experts in. So I'm gonna have to approach the court and request additional funds for those experts if we're reset. So I would ask the court either to give us some preference tomorrow for trial, or if we can't do that, to release Mr. Rios so that he can go to work.
All right, be here exactly at 9:30, okay?
Okay, yes.
All right, I'm supposed to be here exactly at 9:30.
You understand? Now, Your Honor, respectfully, every time we come to court, we lose an entire day of work ourselves too. This is not typical of most of the courts in this county.
Oh, yeah, it is very typical.
It's not.
Yes, it is.
You can say that, Judge, but I practice in
And
the
say
courts.
And it very is typical, because every attorney that's here has a case that's set for jury trial. And this is what ends up happening. What ends up happening is I will allow people to go to civil cases to be out of county, and then their client is sitting here waiting for them. And for some reason, that's the court's fault. That's not the court's fault when attorneys are not showing up at 9 or whatever, and then they stroll in at 9:30 or 9:45. So what I'm telling you all, 9:30, see y'all at 9:30. Thank you. Coordinator will give you a reset form.
Understood. Your
All
Honor,
right,
I'm
thank
trying to make
you.
a record. I don't see the court reporter typing.
What?
Okay, so we only take a record in this court when the judge tells you to? The case was called.
No, the case wasn't called. When I call the case, I call it by the style of the case.
Okay.
All right? All right, so I'll see y'all at 9:30.
Judge, I have to ask you, is this a tactic on the court's part to attempt to wear out the defendant so they can't access their right to trial?
Oh. I find that very inappropriate to say when there is no proof and people are just throwing things out. Now, what I can tell you, and I'm sure your client is aware, sometimes when we end up coming to court, we come to court because there are discovery issues. Sometimes when you're in court, you are in court because your attorney is late. And when I say late, I mean that when a case is scheduled in this court and it's scheduled for 9 a.m. and attorneys go to different courts because they want to go to different courts first, it is not the court's fault that you're sitting here for 12 o'clock or 1:30 or coming back over break. Number one, I have a lunch break. And there was a point in time where I would not take a lunch break. And the reason why I wouldn't take a lunch break is because I said, you know what?
Make a record?
I've been a defense attorney. And when I was a defense attorney, what I would always do, I'm like, I have to be in like 5 courts. It would be nice if they could stagger their docket. And so sometimes I would be here, we wouldn't have a lunch break, and I would be here till 3 o'clock. And then you know what I discovered? When I would say that I want to be here till 3 o'clock, I'm working through lunch, other attorneys, you know what they would end up doing? Then they wouldn't show up in the morning. They would just show up at 1:30 or whatever, because they're like, oh, the judge is going to stay there. So I stopped doing that because I need a lunch break. And that's what happens.
So then my other question, I guess, is if you're not doing this to cause the hardship, it obviously causes on all the attorneys and the defendants. Are you doing this for the YouTube? Because we don't have a record, right? Except for the YouTube.
Yes, here's the thing. You're to be back tomorrow at 9:30. You
Yes.
understand?
Yes.
All right, thank you so much. And once you sign the reset form, you'll be here tomorrow. If somebody goes before you, somebody goes before you. Your counsel is well aware, or should be well aware, if he's been practicing in Bear County,
For almost
that
20
there
years.
are a lot of cases that are on the docket for jury trial. So for example, I had approximately 40 cases down for jury trial today. And what ends up happening, sometimes people who are in custody take precedent because their cases are
I'm
older than
asking for a
yours.
record, by the way.
You understand? Because they're older than yours. So that's what happens. So then what
Rulings
ends
are
up
being made, there
happening,
should be a record, right?
excuse me, stop interrupting me.
Well, we're not on the record,
Stop interrupting me.
right? I mean, we're not in
Stop
court. if there's no record.
interrupting me.
Sir, here's your reset form at 9:30.
So what ends up happening, sir, is that people who are in custody, sometimes their cases take precedent. And the reason why it takes precedent is because their cases are older and because the jail is overcrowded. Now, as you may or may not be aware, I call the docket all the time at 9 a.m. And sometimes when I call the docket at 9 a.m., defense attorneys are not here. Your attorney knows when he has not been here at 9 a.m. And then you have to wait. And you
Judge,
need
you're
to
aware
be
that every
here.
court starts at 9.
And you need to
I have
be
other
here.
cases.
And you need to be here at 9. So when your attorney is somewhere at another court, you know what ends up happening? Your attorney has made the choice to have you sit here and go to another court before
Well,
coming
that's not
here.
exactly true,
You
because all of
understand?
those courts got
All right,
business
good luck to
accomplished.
you.
All
Thank
of us
you.
got
Thank you,
recalled
sir.
today,
Thank you,
right,
sir.
Judge? So, I mean, what did we accomplish?
Have a nice
today?
afternoon, sir.
I
Sir,
mean, that's the reason I don't come to your court at 9, because I know in another court,
Sir,
some things
here's your
can actually
reset.
occur.
sir,
And they're courts of exactly the same
Sir.
jurisdiction.
right this way, sir.
Yes. Manuel Rodriguez. All right.
Are we on the record?
No, we're not on the record yet.
Could I request that we be on the record? It's a motion for continuance that I'm asking the court to consider.
All right. Are you the attorney on this case?
I am not, Your Honor. And that's part of the basis for the continuance.
Who's the attorney?
Lee Cutter's the attorney of
And where is
record.
she?
She is on her way to Guadalupe County for another criminal matter, Your Honor, and she's going to be there probably the majority of the morning. And then in the afternoon, she's specially set in front of District Judge Forte.
Okay, well, she'll need to stop over here in this afternoon.
Um,
Because let me ask you this,
yes,
the matter that she's going to another county for, is that a jury trial?
it's not a jury trial to my
This
understanding.
is, she should have came here first.
I understand that, Your Honor. If I could just be heard at.
No, she needs to be here. I don't know why people are thinking that this is not a criminal district court and that attorneys don't need to come here. This is a jury trial. Where she's going out of county is not a jury trial. This case, I'm sorry, sir, what's your name? Manuel Rodriguez. Thank you. Wow. This case has been set for jury trial. This is the 8th setting. So I don't know why someone would go to another county as opposed to coming to a court where they have a jury trial set. So we will not be going on the record. She will need to be here.
I understand that, Your Honor, and from my understanding of it, there was a jury trial setting in November and December, but those were actually settings for bond motions, so I don't know that they're actually true trial settings, Your Honor.
We're here today for a jury trial.
And I understand, and I did approach the court yesterday with the motion for continuance.
Yeah,
because
and I was not hearing that. I want you to hear me clearly. That attorney is in another county for a case that's not set for jury trial. This is set for jury trial this morning. I don't understand why people don't understand that, one, and I consider myself reasonable, one, that jury trials criminal jury trials take precedence over civil matters. I don't know why people don't understand that. District court matters take precedent over misdemeanor courts. I don't know why attorneys are acting as though they don't understand that. So we will not be going on record. I will not be hearing this motion. She needs to be here. So whenever she comes back from that other county that she's in, I will hear that motion.
I understand. Your
And
Honor.
whether or not I grant her motion for continuance, I do not know. But what I do know, and she needs to be informed of, is that criminal matters take precedence over civil matters. And when I give people leave to do civil cases beforehand, that's me being kind, but they don't take precedence. And so go forth and tell other attorneys that, one, district court takes precedent over misdemeanors because people seem to have forgotten that, and that district court matters take precedence over civil matters. And that anytime there's a jury trial set, at least in the 187th, and you're going to some other county and that's not a jury trial setting and it's not specially set, they need to be here.
I understand, Your Honor.
All right, thank you.
Thank you.
All right, so if y'all put that on the record that you're waiving his presence. All righty, let me find it. And are you ready to proceed?
Sort of. Defense did file a request. I did respond to that request. I'm sure there's a copy of it. I do have a copy. If you'd like.
Yes.
And then today I was handed an affidavit that I reviewed. My response doesn't address the affidavit, so I guess I can just.
Okay, where's the affidavit? Because I don't have it.
I gave a copy to the court. It should be with the court's file.
It's attached right behind.
All right, so this deputy will need to be called.
That was gonna be my argument.
All right. And then I need to know which juror was that? Was that a alternate? Who is it?
That's why we're trying to get the juror card so we can investigate that. So
Well, no, I mean, she should be able to tell us who it is.
and I think the whole basis of the motion is there needs to be good cause.
Yes.
And so far in the motion, the defense has filed, and even if this affidavit, which is hearsay, I don't think there is enough. There are any good cause.
Okay.
And Judge, again, so today's day 30, so that's why we're here trying to get the juror cards. I'm not trying to ask the court or the prosecutor.
Oh,
to-
no, there needs to be evidence submitted to the court
And
in order for the court to give juror cards.
Right.
And
there-
this, what you're giving to me, this affidavit, it's all hearsay. So,
Any affidavit's gonna be hearsay, even the bailiff getting
yeah, so,
information from a.
well,
juror
what I'm
is
telling you
hearsay.
is it's hearsay. So
All
what
of
I
it's
need
gonna be
is
hearsay.
that witness,
That's why I
whatever you
need the
have needs to
juror.
come in. No,
The
the juror
only-
doesn't need to come in. Whoever is making this affidavit needs to come in.
Thomas Lang?
What
No,
is-
the person he obtained the information from.
They're obtaining, and it's all obtaining information from someone else. We need the source, which is the juror.
No, the source is the bailiff who your witness, Thomas Lane, is saying they obtained this statement from a deputy who's not the deputy in the 187th. So that deputy needs to be here.
So the court is ruling that this affidavit that a bailiff is
Yes.
saying that they didn't take it is not good cause.
No, it's not. You'll need the deputy here.
Okay, so again, today's day 30, so I guess I can try to get him here, or I'll file the motion for new trial, and then if the court grants a hearing, I can issue subpoenas at that time.
However you all want to do your case is completely up to you all.
Well, there's no real hearing date because it's just trying to get juror cards. So I don't know if I really am able to subpoena somebody for that
Right.
based on that. So that's why we attempted to get an affidavit from someone else who's an officer of the court. So, but I guess I don't know. It's for good cause. We're trying to make sure that the judicial system worked properly, that everything was followed properly. So I'm not sure.
No, the court determines whether or not it's good cause. And to go into documents to have the court release jurors' information based upon hearsay is not enough. So what you need is whoever this person is that Lane obtained information from, then that person needs to come in and testify. The court is not going to release all 14 jurors' information based upon this deputy saying that they spoke to a juror or one juror spoke to them. That doesn't mean you get every single juror's information, and that's what you're asking for.
And we would need to ask each juror, did that juror tell you?
No,
Did
you
they-
need to
did they
ask,
ask specifically?
no, you would need the deputy. Because according to that affidavit,
That
it's
it
saying
still
that,
wouldn't- Oh, I'm sorry, I'm
No.
interrupting.
so here's the thing. That deputy who's alleged to have told Thomas Lane something, then they need to come in and testify and say, yes, this is what I said, and this is the specific juror I spoke to. What I am telling you is I am not going to release 14 jurors' information based upon a hearsay statement from Lane. You would need to have that deputy to come in and say, this is the juror I spoke to. Or who spoke to me.
We would still request all the juror information, asking if that juror relayed any of that information to them.
And what
during
I'm
the
telling you
deliberation.
is I'm not going to release the information to anyone, state or the defense, of 14 jurors when, according to the affidavit that is here, the deputy is saying it was one juror. That's what I'm telling you.
So we can't even get their names,
No,
even though the court puts their names on YouTube and leaves it
No.
out there.
and I did not put their names on YouTube. So let's be honest and truthful. I do not put the names or the faces of any jurors on YouTube. I know people like to say things, but that is not true. So here's my suggestion, and I'm not telling anybody how to run their case, but it appears that people keep asking me for things that I'm not giving them. So I want to be very clear. I am not giving the state or the defense 14 jurors' names, addresses, and information based upon a hearsay statement. What I suggest you all do is, if this deputy is saying that something happened, and that is not a deputy that's in this court, I would suggest you get that deputy in here to say, specifically, this is the juror I spoke to. Now, according to your affidavit, if everybody's taking that affidavit as true, she is saying it's one juror. There is no way I'm giving people 14 jurors' name when it's alleged to be one juror. The end. Is there anything else? All right, thank you. All right, thank you. All right, we're taking our recess. All right, who's the prosecutor?
Mr. Garrett has my selection.
All right, and so that the record can be clear, the court is aware of who can and cannot appear by Zoom and who the court gave permission to appear by Zoom and not by Zoom. So there's no need to come in hot with, you told her she could appear by Zoom. I already know that it's on the docket sheet. The Zoom link changes, and it changes every single month. The clerks in the back do not have the Zoom link. Once they come out here, that's when they're given the Zoom link. So where are we on discovery?
Well, Judge, may I respond? Because I think
No.
that it is, well,
Where are we on discovery?
I think that is
Where are we on
I
discovery?
call, I think, Judge, I feel like you don't want to hear the response, but it's important because this happens to people. What happened was I came yesterday, I wanted to get the Zoom link. I actually checked.
I don't give the Zoom
they
link the
checked-
day before.
Yeah, they checked the docket.
I don't give the Zoom.
They said there was
It
no,
has Zoom reading right there. You
But-
see that on the docket? What does it say? Zoom. You know what that means?
but then the
That
court
means
issued a
that your
bond
client,
forfeiture.
I have not issued a
Well,
bond forfeiture.
on the video.
All right,
it
so
went to my
here's the
client.
thing. Where are we on discovery?
Discovery Judge, it's Northeast, Methodist Hospital. It was requested. We've looked, when we went up during lunch, we have not received those records from the hospital. So they're not in our possession, at this point.
So when will you have those? Because we've been waiting
It was.
for a while.
Sorry to interrupt. They were supposed to be here. I think the subpoenas mentioned September 25th. If I'm incorrect. I don't know, but they were supposed to be.
You're
here.
correct, because it's on the docket.
Okay, and we don't have them. So they're not in the state's possession at this point. And when we were during the lunch break, I had the discussion with my investigator to hunt those down, and we're probably gonna have to request them again. I just don't know why that they have not responded.
All right, so what I have is the outstanding medical discovery, and it's your client's discovery. Miss Malik, if you can start your video, please.
She's been trying to juggle a bunch of stuff. She's been on and off since she.
All
Yes,
right.
ma'am.
What I have is outstanding medical records of your client, and the state was to upload. Is there different medical records that we're looking for?
Judge, what we're looking for is there was an emergency detention on the
Mhm.
day that my client got taken into custody. So they are trying to get the police / you probably hospital / court documents / all of that should be in those medical records. So we're trying to get those.
All right, so do y'all know maybe if, usually those records, if she was taken into custody and then had the emergency detention, sometimes the sheriff's office may have them in their records potentially. And when I say the sheriff's office, I mean their health department, their infirmary. So they may have it.
Right, sometimes university has the beginning ones, and I think that's what we're trying to look for.
I guess, they're actually, I was unaware of I might have been before the discussions, but I'm not remembering independently. But the only thing that I've seen that we requested is Northeast Methodist Hospital records. But if they took her into custody or emergency detention, there should be a report. So
Yes.
I don't know if that report's in the file or not, but.
The police report's in the file, and I know just you have a million cases and that this one is, you know a little of it, but it's in the police report that's what happened, and that's why we're trying to get that.
So do y'all think they may have it at the sheriff's?
It could. If it says in the police report, emergency detention judge, that might be what they used. And then any type of document, like the page, whatever that they fill out when they take her to the hospital, it would be at the
USB
hospital.
to Mr. Edelman to do that, so,
Okay, that's CPS.
yeah.
All right, and what I can tell you too, if that's the when you say CPS, you mean Child Protective Services? All right, has anybody looked at that? Because sometimes if there's an emergency detention, they will have it in the CPS records as well.
They have a USB. I don't have the full copy of that. They probably, I'm guessing, have part of it. And then we're still gonna need, the rest, but yeah, I think that's a good starting point.
All right, so this is what I am going to do.
Is it new?
It says other police report.
Oh, I don't know if it's uploaded. I saw a NOAD and I saw something else that was uploaded in the NOAD.
All right, so we're gonna recall this back on November 21st to see where we're at by discovery.
Okay.
And so if y'all can look once you get the CPS records, look in there and see if it's there. And if somebody can check with the jail to see if they have any documentation.
I'm gone that week, Judge,
Mhm.
and so if I can, if you're fine with me appearing by Zoom, I can appear by Zoom, but I'll be out of state. I have a wedding on the 22nd. I think that's a Thursday. I have a wedding on the 2nd. So if you could do it either the week before or the week after
We can bring it up
Thanksgiving.
on the 14th.
Okay, we can try for that. That's perfect.
All right, so we're coming back on the 14th.
Feels great.
Because,
That's a good start.
that's why, because I did mark on here and I checked off that we have the CPS records and the emergency detention or medical records. I believe that because this envelope that I just showed to the court and defense counsel, it was not opened.
Okay,
And
so,
so, and I believe it's patient, so I believe we have both. And
all
I
right, so
just-
then what
so
we'll
just
do
hard
then
drive
is,
Well,
from
we-
the defense.
State, you'll need to, we're gonna reset this to December 2nd, and State, you need to be prepared to tender an offer on that day.
Yes.
All right.
And I'm gonna look at this, Judge, and I'll let you know, because I think if it doesn't have the court stuff and everything, I will let them know, hey, there may be some other, because I think that if it is an ED, there should have been a court order, and if the medical has it, they have it, but I also kind of want to see the court stuff, so I've asked them to see if they can possibly look into that as well.
All right, we'll come back on December 2nd. State, at that time, you need to be prepared to tender our offer.
All right, Judge.
Okay, perfect, thank you.
Thank you. And hey, Chair,
Goldberg, come forward.
Appreciate it.
So on this system, and it has Daniel Vela listed as
Well,
attorney.
I think that I'm supposed to be lead counsel with him, and somehow I have to check and see what's going on with that, so.
All right, so if he's on the system and you're not, it shows that he's on the system.
Yeah, but he's on it, we're co-counsel on it.
Well, no,
so-
he would have been notified.
No, Norma checked, he wasn't notified.
Well,
and
here's
his
the
office
thing,
checked.
this was set for August 20th. And there was a no-show by the defense attorney and Mr. Goldberg.
Yep, and Norma checked.
Okay, so let me finish speaking.
Okay.
All right, everybody, take a breath. Calm down. Let me finish speaking. So he was set on August 20th. And the court is aware that sometimes there's some issues with the system. And your attorney listed on the system is Daniel Vela. She's not listed on the system as your attorney. Now, whether she's second chair of their co-counsel, doesn't matter. If she's not in the system, she's not gonna get notice. No, stop. The only person who's gonna get notice is the person who's on the system. I will tell you who Daniel is. Daniel, she said, is her co-counsel on this case, and he's the person who's listed. So if you don't know Daniel, then you probably should introduce yourself, or he shouldn't be listed on the system. So this was scheduled on August 20th. Because there have been issues with the system, I don't immediately issue a bond forfeiture because maybe somebody didn't get notice. So Ms. Ferguson will send out an email or contact or text the attorney. So that's why this case was set on August 20th, and I didn't do anything. But what I wrote on the docket sheet is recall for August 22nd, 2024, and I have no show, defense attorney and defendant. And then I put no notice in the system. So that is why we're here today. So who's the prosecutor on Gabriel Maurice Gobert? All right. State, is all of the discovery uploaded? All right, have you checked to see if any discovery is uploaded? All right, are you able to look and see if the discovery is uploaded? It's, do you need the cost number?
I will need the JN. Give me a moment to log in.
What I can tell you is I don't have access to the JN number, I don't think.
You want me to look it up?
Yes, please.
It is 212
Just 1 second, he's logging in.
212.
9226.
As I explained, the way that the bond is done, we got out from this.
No, Your Honor, I have not conferred about discovery with Ms. Wetland. So I don't know if there are any items missing that, in her opinion, should be.
All right, so here's my question. What you're looking at, does it show where you have uploaded items?
Yes, Your Honor.
All right, so Ms. Ferguson, set this for discovery in 30 days. And by that time, when you all come back, everybody needs to be prepared to sign an acknowledgement of discovery. What date? All right, and then Ms. Ferguson, is Ms. Whitland now listed as his attorney or no?
Second attorney hire.
Mhm.
But it was never, I guess, converted over correctly.
All right, so we need to make sure that she's on there. What is this?
Yeah, because see, the system's all messed up. Yeah, I should be on there as lead counsel.
Well, I mean, you're not on there, but what I do know is Daniel Vela is listed. You don't know who he is. I understand. She's saying that's her co-counsel. So who is lead? Who is second? doesn't really matter. He's listed on there. And if she wants to be listed as lead counsel, then it needs to be put in the system that she's lead counsel. And the only way it can be put in the system that she's lead counsel is if she files a notice and puts on there that she's lead
Which
counsel.
I did,
All right. All
which I
right, thank
did.
you. Norma, give them the reset form for September 23rd and make sure both parties sign it. Thank you.
It's been probation in 23.
Yeah.
5 years would be 28.
Yes.
Judge, she expires April 2025. The underlying sentence was 5 years.
Yeah, she should be from 2023. That's when she was placed on probation for 5 years.
She was placed on probation for term
No.
of 2 years,
I placed her on probation for 5 years.
and that would be 20 years.
Okay.
Judge, what's notated was, it was state jail, suspended and probated for 5 years,
Yes.
starting on April 10th, 2023. So our system seems to be incorrect.
Okay. All right. then.
So she would not expire until 2028.
All right. And I see that your recommendation, at least probation's recommendation, the office is recommending that she be continued. This is what the court will do. Yes. Yeah, I don't know who's making these recommendations. She's been gone since 2023.
Yes, Judge.
All right. So I'm finding number 4 true. I'm going to deny the motion. I don't know if you're going to be successful on this or not. I'm going to alternate amend conditions. Do you need an updated TAP or can I send her to safety?
Judge did a top evaluation. There are a couple of offenses that are going to prohibit her into any lockdown facility unless those are taken into consideration.
All right, if you all can step back and see what offenses probation is speaking of. Because if she has open cases, there's,
Familiar with those.
what is the open case?
Assault peace officer, harassment public servant, Your Honor.
All right, and so when y'all are making these offers, why do you all think that I do not need to know this? Because nobody told me that she has open pending cases. What is happening with these? I've just been given this. What is happening with these open pending cases?
They're subject to review and haven't been presented to the grand jury. We talked about this the last time we were here. We were not going to, I know you didn't want to get involved in plea negotiations.
Because there was supposed to be a contested hearing today.
That was on the MTR because of the circumstances, but we've come to an agreement. Different prosecutor, we were able to have a meeting of the minds.
And Judge, the supervising officer is present today.
Did y'all even confer with the supervising officer before y'all reach y'all agreement? Did anybody talk to the person who was subpoenaed to be here?
I didn't subpoena.
Why would you all approach me? And I keep saying, talk to probation, and this is a contested hearing, and probation has brought this officer here who's needed back, looking at other people. You all need to go confer with her. Go confer with her.
Go have a seat, ma'am.